excited to chat with you all a little bit about this proposed legislation. There are two versions of the bill that we'll be discussing, and that's why we reference both the Senate, which is SB 1486, and HB 1083. But we're here today to pretty much focus on the portions of those pieces of proposed legislation that deal with adoption, and more particularly with child welfare adoptions. Katie and I are pretty familiar with this topic. We have handled, gosh, in the last 3 years or so, several appellate cases that have ranged from the Treasure Coast all the way to Central Florida and back again down to Miami that have dealt with, more than anything, these particularly nuanced contested DCF adoptions. So we have handled everything from the trial court level through appeals, and that's why we're here today to present on this particular piece of legislation, because we are so concerned about it. It is basically being proposed in the House by Representative Trabulsi, who is located here in the Treasure Coast, and it is being put forth in the Senate by Senator Collins, who's out in Hillsborough. And again, the main point of today's presentation is to really explain to particularly custodians of children who are either free for adoption, or basically they have kids in their care, or they care about children that are going to be freed up for adoption, and what's on the line as it relates to those children that they know and love in regards to this piece of legislation. Katie, you heard her turn on the record button maybe. We are recording this so that people can view the webinar, not the question portion, but the webinar, the main meat of the presentation, offline later on. So if people want to go back to our website, they're more than welcome to review the material there as well. So basically, I want to take a few minutes to essentially talk about the three main issues, or the main points that I want to really hammer home about this legislation. We are going to get into some nuances here and there, but the three real big issues here that we want to make clear to you all as people who care about foster children is that this piece of proposed law removes the best interest consideration from the court. It replaces that best interest consideration with basically a deference to DCF in their adoptive selection decisions. And then it also, in doing all of this, deprives prospective adoptive parents and the children that they care about of their rights under the law. And this isn't something that's unique or new. Katie and I could probably tell you that we've reviewed in the last 3 years, 3 different iterations of a bill just like this. So basically, DCF is trying desperately to change the law as it comes to adoption and adoption selection, and essentially is bound and determined to deprive custodians, prospective adoptive parents, of their rights. So it's really important, and I'm hopeful that one of the main takeaways you'll also leave with today is that you will take this as an incentive to kind of reach out to legislators and say, hey, listen, I am not happy with what DCF is trying to do with this bill, even if it doesn't get passed, because we know that this will come up again, even if it doesn't make it through and actually become law now. So before we get to the real specifics of this really controversial piece of legislation, so let me go ahead and get my screen up so you guys can take a look at what I'm talking about. Okay. All right, can you all see my screen, Katie?
Yes.
Great. Okay. So before we get to the contested side of DCF adoptions, I want to talk about what the adoption process looks like in Florida. So in Florida, in uncontested situations for child welfare adoptions, it's very straightforward. You go through a home study, you do some background checks, just like if you're a foster parent, what happened when you got licensed, you do your interviews, you get matched if you're not matched previously through placement when a child was placed in your care because the parent was maybe like working a reunification case plan. Everything goes smoothly, hopefully. And then DCF issues what is necessary under the law, their consent to the adoption. So what that means is in every adoption case, and unless we get into these contested cases, DCF usually, it's a one-page piece of paper. They sign off saying, yes, we agree to this adoption. Then once they do that, you get a hearing before the judge. Everything is wonderful. Finalization occurs, and that is the wonderful, beautiful process of adoption in Florida, as long as there are no basically competing applicants or other issues. So if there are contested issues at all, then you end up with an adoption. Oh, hold on, let me go back. There we go. There we go. We end up with an adoption application review committee meeting. So that's the big question, right? What if DCF doesn't issue that consent that we talked about, that one page liner, that one thing that the court needs to finalize the adoption? Well, they basically go through the process where they have what's called an adoption application review. And that's a committee that meets, and I know some people may be familiar with that process already, but that's a committee that meets in situations where more often than not, you have more than one family that is asking to be able to adopt a child out of the child welfare system. Or you've got a situation where the adoption applicant has maybe a criminal history that may make them a disqualifier, like that may be a disqualifier for them to be able to adopt. Or there's an abuse history with that prospective adoptive parent, and they have to get clearance from the adoption application review committee in order to be able to be considered for adoption. So if DCF holds this adoption application review committee meeting and they decide that the applicant that is you or someone you love is not going to adopt, they will issue what's called a denial letter. That denial letter gets mailed out to the denied applicant, and the denied applicant has two choices. They can, one, appeal that decision directly to DCF's hearing officer, which is what we call as lawyers an administrative proceeding. So basically what it is you have a DCF employee, a DCF general counsel attorney, deciding whether or not this internal meeting, which was conducted by other DCF employees, was appropriate. Was their decision appropriate? It is essentially what we have called a star chamber, where there is no real review of the decision below, and the hearing officer just kind of goes, yeah, no, we're fine with what DCF did here in their adoption application review committee meeting. So sorry, denied applicant. Yeah, we understand you want us to review it, but there's really no options for you here. You're done. But the other option that Florida law has established, and that has been very, very clear since 2004 and even before then, is that you can, as a denied applicant, go ahead and once you receive that denial letter, actually run to the courthouse and file your own adoption petition. And the nice thing about that is that you, in that case, are the adoption petitioner, which means you have a full set of rights to call witnesses, to do discovery, which is just a fancy word in the law that basically just allows you to look at DCF records and really take a close look as to whether or not the decision that they made was appropriate as the petitioner. So you get all these rights. You get to set a trial date. You get to decide who you call as a witness, like I mentioned earlier. There's all these things that you get to do as the adoption petitioner. And that's the way the law is set up now. You get to do this. You have two choices. You can pick one or the other. Sometimes you see attorneys do kind of a little bit of both. Maybe they start out with an ARC review and then they decide, no, we're going to go with the adoption petition. Whatever it may be, you have choices. And more importantly, you have rights as the adoption petitioner. So what is most concerning to us is that these rights are going to be basically stripped from you in this new piece of legislation. So in the law as it stands right now, the judge has to essentially go through a full best interest analysis, right? So like I said before, the court has the right to do a best interest analysis where it can look at the conclusion of the adoption trial, where you as the denied applicant filed the adoption petition, held the trial, presented all of your evidence, cross-examined witnesses, called witnesses, all that good stuff. The court gets to basically decide under a three-pronged test whether or not DCF's decision was reasonable. And so the court will ask itself, did DCF make an appropriate selection here when it was meeting as the ARC and deciding who gets to adopt? So in other words, that's the big best interest consideration, right? So that appropriateness prong is really the court asking itself.
Right. The same lady, same doctor, she's great. She's uninsured people.
Of this child. And then the second thing that the court will ask is whether or not DCF's decision to deny the adoption application of the denied applicant was, it's a fancy legal term, but it's consonant with policies of the department as approved by the Florida legislature. So in other words, the way I interpret that second prong is that it basically says the judge has to ask himself or herself, does this decision align with Florida statutes? And then finally, there's the determination by the court as to whether or not DCF's decision to accept or deny or make an adoptive selection was expeditious. And there's a lot of controversy over that third prong because DCF would like the court to think that that clock, that timeline starts once a child is free for adoption. So that means that basically once all appellate remedies have been exhausted, the parents have lost their TPR trial, or they've, decided that they wanted to appeal that decision to the higher court. The appellate court has reviewed everything and ultimately determined that there was no issue with the TPR and issued a mandate. DCF would like the court to start counting from that day. But that's not what Florida law says. Not only that, but federal law says the complete opposite too. So Florida law and federal law is very clear that there's this thing where DCF has to, and I'm sure you may have heard this in different hearings, that DCF has to concurrently plan for children that are in the child welfare system. So what that means is that the minute there's a concurrent goal of adoption, the department has to start planning for the adoption of this child. And we all know, having been in the child welfare system, that these adoption goals, concurrent goals of adoption, can be issued very quickly in a case. So even if the parents' rights aren't terminated and a mandate isn't issued and all the appellate remedies aren't exhausted until like 2 or 3 more years from shelter, that concurrent goal of adoption could have been issued 9 months in the case. So there's a lot of controversy there, but it's still, the benefit to adoptive parents is that they get to argue that before the court. They get to argue this expeditiousness prong as the law stands today. Now, if this law changes, all of that goes away. Basically, what this law proposes to do, what these 2 bills propose to do, is they first and foremost eliminate the opportunity or the option for all denied applicants to appeal the denial to the administrative officer from DCF. So yeah, it's not the most ideal situation always to appeal to DCF hearing officers because for all intents and purposes, they're pretty biased, but it's still an option. You still have that right, okay? This legislation does away with that completely. The only option available to denied applicants under the proposed legislation is to have a hearing in front of the child welfare judge. So no longer, if you receive that denial letter, do you have the right to immediately run to the courthouse, file your adoption petition, and ask for the court to override DCF's denial. No. What you have to do now, if this law passes, is you have to actually ask permission from the trial court to even file that adoption petition. And that permission is only given to you after you win, as I note in my presentation, at a hearing. So not a trial, but at a hearing on the reasonableness of DCF's denial. So as I said before, yeah, in the adoption petition, the court is considering the reasonableness as well. But here, you're not getting a trial under this new legislation. You're just getting a hearing. And you, may get to, quote unquote, present evidence to the court, but you're not the petitioner in that case. You're not the adoptive parent petitioning, filing their own paperwork, creating their own case. You're just given permission to file a motion and request that the court basically beg the court for mercy if your adoption application is denied by DCF. And that hearing, the parameters are very, very vague. The law is very, very unclear about how you even get to beg for mercy from the trial judge. You essentially have an opportunity to, quote unquote, present evidence, but there's no clear right to discovery. There's no clear right to cross-examine witnesses. There's no clear right to call witnesses. So the legislation as proposed is entirely violative of all prospective adoptive parents' rights and the children's rights that are in their care. And so the one thing I did want to highlight in this proposed legislation, outside of the fact that you don't get to file an adoption petition anymore, is that there's a totally new standard of review for reasonableness. So instead of having the court consider the best interests of the child and weighing that in the reasonableness consideration or analysis, the court is basically stuck deferring. Their hands are tied. So they're they're having to defer to DCF's decision. And the reason I say that is because you can see in the PowerPoint that first best interest, that appropriateness prong, it's gone. It no longer exists under the law if this bill passes. And basically you're stuck with a situation where the trial court can only look at two things. Instead of looking at whether or not DCF's decision is consonant with state legislature and state law, nope. This time DCF really just gets to basically propose that, Judge, our decision, it was consistent with our policies. It was consistent with our operating procedures. So we made a decision that aligns with what are the rules that we make for ourselves, but we don't have the backdrop, or the judge doesn't have the backdrop necessarily in this particular case, in this new law of the law. It doesn't have the background of the oversight of Florida statutes to really help the trier of fact, the judge, decide whether or not DCF's decisions were reasonable. No, DCF just basically gets to say, Judge, we made a decision. It was consistent with our internal policies and procedures. You don't get to question that. And then, as I mentioned before, there's the expeditiousness prong. So essentially, to kind of conclude, you see there's a huge disparity. There's huge difference between the rights that foster parents and prospective adoptive parents have under the law as it stands today, as opposed to what it will look like if this bill passes. All of the rights that exist will be stripped from prospective adoptive parents, and they'll no longer have the opportunity to really fight or advocate for the children that are in their care the way that they have as the law stands now. So, like I said before, the biggest problems that we have with this piece of legislation are the doing away with the best interest consideration, the deference to DCF that will now be required, and the complete elimination of due process rights for prospective adoptive parents and essentially the children in their care. But there are other things to kind of keep in mind and to consider in this legislation. I understand DCF claims that it has expertise in childcare and obviously in adoptions, but we all know, having worked in the system, that they lack a lot of legal knowledge and experience to make informed adoption decisions. I understand the department and many years they go through what they call adoption competency training, but I will tell you, after having gone through so many examinations of experts in these types of cases, that competency training is inadequate. It does give someone a foundation, but it does not make them an expert on bonding and attachment. The other real consideration here too is the fact that for all intents and purposes, I'm sure DCF thinks that this proposed legislation will help expedite the process for adoptions. But at the end of the day, we all know that the amount of cases that exist in the child welfare system are overwhelming. And what they may think is a good avenue to help alleviate some of that overload really isn't, because basically you're overwhelming the department with these adoption decisions if this legislation passes. And there's a lot of bureaucracy here too. Adoptive families will have to navigate and wander through more bureaucracy if there's not the judicial oversight, there's not the judge having the opportunity to check DCF and its decisions. And that's just not fair to the parents, and it's not fair to the children. There's also a consideration for biological parents here that must be kind of taken into consideration. I understand that parents, by the time we've gotten to the adoption hearings, their rights are terminated. But I will tell you, as having represented several parents in these contested hearings and in pre-TPR cases and in TPR trial, a lot of these parents are willing and able and open to surrendering their children and to being okay with an adoption plan if they know that that's where the child's going to stay long term. If we start to change the process and strip the parents and the children, the adoptive parents and the children of the right to advocate for themselves in front of the judge, you're essentially undermining the biological parents' wishes, who essentially were, in some cases, consenting to an adoption plan because they thought that this child was going to be adopted by their foster parent, or they were going to be adopted by a relative who had custody. And if we continue to pursue legislation like this, you're essentially depriving or slapping parents one more time in their faces as to their rights to make adoption plans and to parent their child if they choose to do that in and through an adoption. And more than anything, I think here, there's been a lot of talk over the years about trying to make and give custodians rights. We've seen the changes to 39522, the changes to the post-dispo change of custody portions of the statute that have allowed foster parents and other custodians significant rights in the last couple of years. But if this continues, if this trend in adoption continues, we're essentially allowing DCF to not be accountable for its actions. There's no way to check them on the decisions that they make if legislation like this goes forward. And I'll just give you a quick example. We're going to end up with an unjust outcome in these particular cases if you have caseworkers like we've had testify that they're adoption experts. Yeah, they can make decisions about children and child welfare because, and no joke, you guys, we've had witnesses testify to this. They're adoption experts because they study genealogy as a hobby and they know all about it. And they also have a history of understanding cattle breeding, and that allows them to make a decision about a child's future. Those two things qualify them as an adoption expert. And without the ability to cross-examine that witness at an adoption trial, that information would have never come to light. The court would have never heard that ridiculous statement by a caseworker as to why she was an expert. And I know we're running out of time, and I do want to leave some time for questions, but I just want to quickly cover a couple of additional considerations from this proposed legislation. I think that folks that are custodians, whether you're foster parent or relative or non-relative, there are some things to consider here, as this piece of legislation does also allow the department to move forward with some expedited removal. So they could basically come in and remove children from established, bonded caregivers if these caregivers, as it says in the law or proposed law, violate the terms of placement as ordered by the court. So and Katie, I think, agrees, and she may chime in here at some point too to kind of expound on some of this stuff. But I think that particular portion of the law, although it doesn't really concern adoption, is really significant because we've had cases where the department has matched children with prospective adoptive parents, and the prospective adoptive parent has signed all the paperwork, including what's called a memorandum of agreement to accept children into their home for purposes of adoption. And a few months down the road, DCF doesn't like the behavior of the pre-adoptive parent, and they decide to basically move to change the custody of that child, essentially arguing that this set of prospective adoptive parents has violated the terms of the condition of placement for whatever reason. And so I think that that's something to also kind of look out for in this legislation, is that they're trying to kind of make inroads here and there so as to avoid having to have a court hearing about a change of custody.